Good afternoon, ladies and gentlemen, or considering where I'm coming from, I should probably begin. May it please the court. Let me express my thanks and my appreciation that you are able to accommodate me at this hour. I know you are busy, you have texts to read, exams to prepare for, tutorial sheets to swat. But I could only do it at this hour, so I am grateful. I understand that we are being joined by students at Cave Hill. I send greetings to them also. I am glad to be back in Barbados, even if only virtually, having not seen the island since I did my law degree there. Now, what we're going to look at today is a law in relation to sexual offenses in the Caribbean. And like any good lawyer, I am giving a disclaimer. Some images and quotes used in this presentation may be disturbing and offensive, but are used for illustrative purposes, and in no way reflect the personal views or biases of me, and by extension, the Office of the Director of Public Prosecutions, and by further extension, Ms. Paula Llewellyn, my boss. So, you all have the opportunity now. Those of you who know you are going to be offended, you can leave now. I assure you, I will not be offended if you leave, but I'm giving you a chance. Going once, going twice, going thrice. Very well, you have all waived your right to be offended. You can lash me on social media after this or so on, but if you stay here, you cannot express any offense. So ladies and gentlemen, we are looking at sex. And the truth is, we live in a phallocentric and vagicentric age. Everything touches and surrounds sex. And for some people, it seems that people have heard that God is going to take it back. And so, you know, there is this great rush and so on. Especially for those who are on university campuses. Some of you have just moved here from country. Some of you here held important positions in your church, youth leaders, student pastors, so on. And then you come to the secular plural environment in which your skin catch a fire. And some of you broke out. And some of the broke out is permanent, then the people never ever go back to what they were by the time they came here. And the truth is, sex is a good thing. We derive much enjoyment from it. We derive much titillation also from it. But the truth is also, is that sex has wounded many persons. And if I go by statistics, either male or female, there are some of you here, seated, either here or in Barbados, that an attempt may have been made on you, either rape, grievous sexual assault, or some kind of indecent assault, and usually by somebody that you have trusted. Very rarely a stranger. So, I give the statistics, which are real United States statistics. But in the files that I read, in fact, I am going to the St. Mary Circuit soon, and I must tell you that I am just surprised. I have quite a number of sex under 16 cases which took place at the back of the Onoto Bay Library, which took place at a bus shed in the middle of the day, which took place in bush on the side of the road. So a lot of these cases happen, and there are persons of varying ages, teenagers, children, infants. So sex has been with us from a long time. So if you look at this picture, this is actually a picture of the creation myth in ancient Egypt. The goddess of the sky, that is the female who is overarching the very tumnescent male, who is the god of the earth, Jeb. And according to ancient Egyptian mythology, this is how the world and the universe was created. Let's go to ancient Rome. Quite sure this must be very painful. But this was the god of livestock, fruit plants, and gardens. And you will note that if you look in ancient religions, agricultural gods were always linked with fertility. And he was an agricultural god. So if you're a Roman farmer, you would have statues of this god on your farm, especially where you have your livestock and your cultivation. From ancient India, the religion of Hinduism, the culture that gave us the Kama Sutra. This is from a temple in India. So they have elevated it to worship in that sense. So the person's coming to worship at the temple. Just as how you have crosses and stained glass windows, well, for some Hindus, this is what arouses their religious desire, to be closer to God or gods. Let's not leave out the Bible. Ezekiel 23, 19 to 21, and let me read it. And the King James Version gives it quite well. Yet she became more and more promiscuous as she recalled the days of her youth when she was a prostitute in Egypt. There she lusted after her lovers whose genitals were like those of donkeys and whose emission was like that of horses. So you longed for the lewdness of your youth when in Egypt your bosom was caressed and your young breasts fondled. Can I get an amen or a hallelujah? So the Bible itself, and by the way, the prophet Ezekiel actually was speaking about Israel and speaking about Israel's foreign relations. So it's actually a political parable, but put in this kind of language. Then there is high literature. D.H. Lawrence, Lady Chatterley's Lover. And perhaps if you do optional course in your third year or when you come to do constitutional law, this book was the subject of a very famous obscenity trial. And you will discover that when you come to look at things like these, obscenity is hard to define. A U.S. Supreme Court judge once said, he can't define pornography, but he knows it when he sees it. And so obscenity tends to fall within that category. So I give an extract from the book, which at that time was very lewd, but if you read it now, it's really quite tame. You know, he too had bared the front part of his body, which actually sounds very clinical. And she felt his naked flesh against her as he came into her. From the moment he was still inside her, turgid there and quivering. Then as he began to move in the sudden helpless orgasm, now, nothing I have read sounds obscene so far. But if you lived in early 20th century England, this was high pornography. And so on. So this is just an extract from Lady Chatterley's Lover. Then you have fringe movements, like the environmental movement, which has spawned the ecosexuals. Have sex with earth to save it. Earth as lover, not mother. We can probably say it will work out in climate change. But people have used sex also to give light to the whole thing of the environment. And perhaps this is the only way some people get wood, if you forgive my very bad joke. Then in the Caribbean, we come to this. Some of you, perhaps, will be jumping up and dressed like this and doing things like this around the ring road around the time of the university carnival. So, for the soca files here, this is Uno. I have not left out our people because in the dance hall, there it is. So sex is prevalent, it is ubiquitous, it is all around us. You know, you wine on the edge, you set good like ice in a freezer, you back up like dumper truck. You know, all these kinds of things. And I date myself because none of these songs that I have quoted from are current. And then, to lead into, before I get into the offenses, law enforcement has not exactly acquitted itself well in relation to how it deals with sexual offenses. Victims of sexual offenses still get a raw deal in our courts. They are still treated badly. Now, this is an example from a judge in California. Well, he couldn't do anything about it because the jury had come back guilty for rape. But in his sentencing remarks, the judge made it known, gave his own opinion, that he didn't believe the complainant. Why? Because if she had been raped, her vagina would have been shredded. And there was none of that medical evidence. So he gave the rapist a low sentence because there was no shredding of her private parts. Then, in relation to sexual attitudes, and this one is relevant to a university campus, especially a campus like this, people eschew personal responsibility. So this was a group, I think they were football players for Vanderbilt University, and the allegations that they gang raped this girl, and they are saying it was the party culture on the campus that led them to do this. So it's not their own morals, it's not their own sense of right and wrong, it's not their respecting of people's dignity and human rights and right to consent. It is a party culture of the school that is to blame as to why I did this. And you hear it all the time, especially in cases where people are sexually violated. Why you are out there late at night? Why you dressed that way? Why I never tell the man, go on? All of these things where we blame the victims or we don't accept that the person who has done the wrong is responsible. And I want to give you an idea of the problem we face. Because I was in court and so on, I did not get the 2019 statistics. But if you will look at the statistics produced by the Jamaica Constabulary Force, and I hope you can all see it, between 2015 to 2018, what do you notice? Sexual offenses are running at the same rate as murders in this country. Let me repeat that again. Sexual offending is committed just as much as murders in this country. But we don't have any SOEs or ZOSOs for sexual offenses. We don't have, let me just say, sexual offenses are not sexy in terms of fighting crime and crime policy in this country, and perhaps for the rest of the Caribbean. So in 2015, you have 2,065, 2016, 1,607, 2017, 1,614, 2018, 1,316. So between 2015 to 2018, there were 6,602 sexual offenses reported by the Jamaica Constabulary Force. How does our office as prosecutors deal with this? What I have done, and let me give a disclaimer, this is my own personal count, going through the books, trying to sectionalize the parishes. So if you look at the table, I have the parish, I have the total number of cases before the court, I have and I try to disaggregate them. How many of them are for like murders? How many are for sexual offenses? How many are for non-fatal offenses against the person? And if you look at it, you will find that these numbers are very surprising. So when prosecutors from my office, we go to the parishes, chances are we are seeing more sex cases than, say, murder cases. And that is because sex cases are easier reported, while murder cases usually take a little time, so they don't come in real time. So this was for the Christmas term of 2018. the Christmas term, between September to December of 2018. So if you look at the parishes, and I have ranked the parishes in which sexual offences occur the most. So in 2018, despite all you hear about one-odd and Klansman and murders and so on in St. Catherine, before the courts, there were more sex cases than murder cases. Out of 462 matters, there were 350 sex cases, or 76% of the list. I must say there's probably something in the Rio Cobre that people are drinking. And then, if you look at the entire eastern end of the island, Portland, St. Mary, and St. Thomas. In Portland, it was 72%. In St. Thomas, it was 71%. In St. Mary, it was 71%. The entire eastern set of the island, those three eastern parishes, the majority of cases in the courts are sex cases, are sexual offending cases. And perhaps there's a reason for that, I don't know. I don't know if it's related to urbanization, I don't know if it's related to being a rural parish, but I can't extrapolate that way because St. Catherine is a mix. St. Catherine is a mix of rural and urban. Let us go down to the bottom of the list, or the middle of the list. The wretched and sinful corporate area. Kingston and St. Andrews, see where it comes on the list? Even though it has the largest number in terms of quantity, in terms of percentage, it's only 45%. Murders are still our popular crime in the corporate area, but only just by barely in that year, 47 to 45%. And then when you come to other parishes like Trelawney, Hanover, even the wild, wild west of St. James, you see it lower in terms of offending. I don't know why some parishes are more prone to sexual offending, but this is the reality. This is what my office deals with on a day-by-day basis. On March 9, some circuits are going to start. Hanover is going to open, St. Elizabeth is going to open, St. Mary is going to open. And we are going to find a high percentage of sexual offending. So, having given that introduction, to give you what the state of Jamaica is in relation to sexual offenses, let us now get into the offending. And although I would try to be regional, a good portion of this is going to be centered on Jamaica. And that's because in preparing, it's much easier for me to prepare for Jamaica than for the other Caribbean territories. And so I will refer to other Caribbean territories, but for the most part, my point of reference is going to be Jamaica. So I mean no insult when I do that. It's just a matter of how I am able to prepare. So the Sexual Offences Act of Jamaica was passed in 2009. And what this act did was to repeal the Incest Punishment Act and those provisions in the Offences Against the Persons Act, which touched and concerned sexual offenses, and it also created modern sexual offenses. It also created a sex offenders registry. Sex offenders registry is not new. Well, it's not unusual. We tend to think of these things as only happening in the United Kingdom, in the United States, or in Canada. But Jamaica and some Caribbean countries do have sex offenders registries. The difference between perhaps Jamaica and perhaps a country or jurisdictions like the United States is that ours are not open to the public. That's a question you'll have to take up with policy. But ours are not open up to the public. So you can't go on the website and say, who is the sex offender living in your neighborhood? And then you can go and burn out his house and that kind of thing. That's what we like to do in this country. In addition to the Sexual Offences Act, I will make brief reference to the Child Pornography Prevention Act, which was also passed in 2009. Now, the Child Pornography Prevention Act deals with images of children engaged in sexual behavior. So the purpose of the creation of the images is that it must be for a sexual purpose. But it is broad in scope because it can be audio and it can be verbal in terms of those words. So this act came into being to deal with, you know how you young people like to share videos and share images and share memes and GIFs and all of these things, and I'm hoping I'm using those terms in context. This is what it was designed to deal with. So if somebody sends you a video, say of children having sex, or somebody having sex with a child, first, the mere act of possessing it is unlawful. The law allows you a reasonable time to get rid of it. And for me, I've interpreted reasonable time to mean immediately. As it comes, you delete it. Whatever. But it must be deleted. If you have it for a week, you can't really say that you had it for a reasonable time before. If you had it for 2 days, it's hard to say it's a reasonable time I can possess it before I delete it. At least that's the argument I am going to make when I have you in my court. If you share it, even if you are expressing your outrage, look upon this, what kind of man this? If you share it, you have distributed it. And then, as I have discovered looking on some of my St. Mary files, people like to film these things. I come from a generation where cameras were never brought into a relationship. But I understand that videos and filming these things are the rage. Which is why there's now a Section 9 of the Cybercrimes Act called Malicious Communication dealing with revenge porn. And if to do a notable case, West Indies cricketer Mr. Lendl had his own revenge porn case adjudicated on in Trinidad and Tobago. So in 2009, the Jamaican government was trying to deal with sexual offending. Sexual Offences Act, Child Pornography Prevention Act. And let me go to the Offences Against the Persons Act in brief. So the Offences Against the Persons Act, and many countries in the Caribbean still have some of these. It's been in effect in Jamaica since 1864, just a little bit before Crown Colony government. It contains a section for unnatural offenses. So when Jamaica enacted the Sexual Offences Act, it did not take out these provisions from the Offences Against the Persons Act. So when you look on the Sexual Offences Act, you will not find certain offenses. You will not find buggery in there. You will not find gross indecency in there. You will not find indecent assault on a male. And that is because Parliament was persuaded by arguments raised by certain people that, look, the Constitution has a savings clause. And have you all done your constitutional law yet? So you know what I'm talking about when I say the savings law clause. So the savings law clause preserves all these laws before the existence of the Constitution. So it was said, if you repeal these provisions and you put it in the Sexual Offences Act, you make these provisions open to constitutional challenge. So Parliament kept it there. So you will observe that whereas in Belize and whereas in Trinidad and Tobago, those challenges have been successful, it's really because they don't have like a savings law clause like what we have. So in order to do it in Jamaica, you would actually have to amend the Constitution, which is difficult. So a judge can't strike it down. You have to go through the whole process, a long and difficult process of amending a constitution in Jamaica. And around the same time as Jamaica, a lot of Caribbean countries passed Sexual Offences Act or sexual legislation. I have a theory that CARICOM employed a consultant at that time perhaps from abroad, and they then shipped out all these model legislations which were adopted by varying parliaments. So Belize, a lot of it is covered by a criminal code. Guyana, Criminal Law Offences Act. St. Kitts and Nevis, they have an Offence Against the Persons Act. Cayman Islands, it's in their penal code. In Antigua, Barbados, Dominica, Guyana, Trinidad and Tobago, there are Sexual Offences Acts, like Jamaica. And in the Bahamas, there's the Sexual Offences and Domestic Violence Acts. In the Bahamas, they have married the two in one legislation. So let us begin. In any sexual offense that we're dealing with, we have to deal with what is sexual intercourse. How is it defined? So this is your standard sexual intercourse, heterosexual sexual intercourse, penis in vagina. So let us look at how it has been defined. So in section 2 of Jamaica's Sexual Offences Act, it has codified the common law definition of sexual intercourse, which means the penetration of the vagina by a penis. So in Jamaica, there's no other kind of sexual behavior that can be classified as sexual intercourse. In Jamaica, it has to be penis in vagina. It should be noted that really and truly it's only the Jamaican and the Bahamian legislation that define sexual intercourse. Now the Bahamian legislation is different from the Jamaican legislation. In the Bahamas, the definition of sexual intercourse is much more expanded than Jamaica. But, so it encompasses penis in vagina, but it also includes a sexual connection occasioned by a penetration of any kind of the vagina or by the anus, by any other part of the body or with an object. So the Bahamas has moved beyond Jamaica in that respect. And the Bahamas also has a sexual connection occasioned by the introduction of any part of the penis into the mouth of another person. So oral sex, whether it is cunnilingus or fellatio, sexual intercourse in the Bahamas. You digitally penetrate somebody, that is your finger them, sexual intercourse in the Bahamas. Or as is described in the use of the language in the Bahamian legislation, a sexual connection. So the Bahamas has a wide definition on their law comparatively to Jamaica, which has a limited definition. So some of these areas, which I'm not going to go into because you are going to get a lecture on it. So for example, in Jamaica, a sexual connection occasioned by the introduction of any part of the penis into the mouth of another person is a grievous sexual assault. But it is not sexual intercourse. If you stick your finger up somebody's bottom or somebody's vagina without their consent, that's also grievous sexual assault in Jamaica, but it is not sexual intercourse. In Guyana, Guyana also has a very expansive definition of sexual intercourse. So their Sexual Offences Act defines penetration to mean any intrusion into the vagina or anus by a part of the body or an object, and also includes the placing of the mouth upon the genitals or anus. So there doesn't even have to be any penetration of the anus or the vagina. You just put your mouth on it, so you kiss it. That in Guyana would qualify as part of their definition of sexual intercourse. So, what are some of the principles in sexual intercourse? One, the slightest penetration is enough. So, there is a feeling in Jamaica, and I suspect it's not unusual in any other part of the Caribbean, that sex only takes place when the penis goes full hilt into the vagina. No. If the tip only pass the labia, you have had sex under the law. There is no need to prove emission or seed. That is, to use the language of the people, the man no need to brook inside or outside. There's no need to prove it. Lastly, and importantly, the hymen does not have to be ruptured for sex to take place. Plenty people feel that if the hymen is not ruptured, is lie the person telling. I did a case in St. Catherine with this man who was having sex with this little girl. And we had to call the doctor on it. Why? Because this girl's hymen could stretch. She had an unusual hymen. So no matter that he had been doing this for days, and he had been doing it till he had his crisis of moment, her hymen was never ruptured. And on medical examination, the doctors discovered that she's one of those unusual persons whose hymen could stretch. So, proof of the hymen is also unnecessary. Moving right along. So, the Joint Select Committee of Parliament, when they were reviewing the Sexual Offences Act, and I would advise for those or other Caribbean nations who may want to compare what is being proposed, and especially for Jamaican students, you should read the Joint Select Committee report on the Sexual Offences Act. The Joint Select Committee, in their report, decided they were not going for an expanded definition of sexual intercourse. They did not give any reasons why they were keeping the present definition. So it is now for Parliament. So the committee has decided they are not expanding it, but it is for now the report goes before the whole House of Parliament for Parliament to decide, say, well, we don't agree with you, Joint Select Committee. We are going to expand the definition. But it's now up to Parliament to say what they will do with the report. Let me move to another important part before I get to the offences. Consent. At the heart of every sexual offence is consent. That is the capacity to consent, and whether consent must be expressed. Let me tell you now. Let me tell you now. Under Jamaican law, and I think also under the other territories of the region, consent must be expressed. You can't infer it. Gentlemen, you can't say her mouth said no, but her eyes were saying yes. You can't do that. Consent must be expressed. You must get actual specific consent for what you are about to engage in. So, there is no statutory definition for consent in the Jamaican Sexual Offences Act. So, I assume that you are doing legal interpretation and statutory construction and so on. In the absence of a statutory definition, you go with the dictionary meaning, which means to agree to do something, give approval, assent, or permission to something proposes. It implies compliance with something proposed or requested, stressing this as an act of the will. Let me just segue here into a little bit on rape and then come back. So plenty of people think that rape, you have to show some kind of batter bruising. You have to show some kind of injury. No. Rape is an offense against the will. And the 3 F's govern it: fear, force, or fraud. If you are afraid, you will give in. It's not willing consent. If you hold on and take it, it's not willing either. And if you trick it out of persons, it is not willing either. So it must be expressed. In Guyana, Guyana is unusual among Caribbean territories, at least among the legislation that I have seen, because Guyana defines consent. So in Guyana, there's a statutory definition for consent. So if, for example, if you look at the Jamaican Sexual Offences Act, you will see what is not consent. So if you look around the rape provisions, you will see the act says, this is not consent. But the act does not say what is consent. But the Guyanese Sexual Offences Act defines consent. And I want to look at it because it means words and they put overt actions. So I guess, for example, if you decide, let me use a male to a female, you decide, say, honey, let us go and have sex. And then she goes and takes off her clothes and lies on the bed and lies down prostrate and says, come. You could say, all right, that's an overt act. She didn't say yes, but her actions tell me that she is willing. So I think that is what they mean. The case law establishes in the context of a criminal trial, consent is to be given its ordinary and natural meaning. And there are two Barbadian cases, and I highlight these especially from those from Cave Hill. Mark Hoyt and the Queen, and J.P. Joel Doyle and the Queen. So Mark Hoyt and the Queen says, it applies an English principle. Mark Hoyt and the Queen says, every consent involves a submission, but every submission does not involve a consent. So that is the principle that Mark Hoyt applied. J.P. Joel Doyle, and J.P. Joel Doyle is an interesting case because it touched and concerned a pastor in Barbados. It was a pastor of this church in Barbados named the Dominion Life Center. And because this is public knowledge, it's actually on a website, I can talk this without no fear that I am libeling or slandering the man. And his conviction was upheld. And the CCGA threw out his appeal. So, young girl, 13, member of his congregation, calls her to his house. Because he's a pastor, you don't think anything. So, picks up herself, wants to see what pastor wants me for. On the facts of the case, how does he meet her? He meets her naked except for a towel wrapped around his torso, his lower torso. And he says, hold on, I am going to bathe. And then she waits while he goes and bathes, and then he comes back naked and then tells her something, and she has sex. So she was 13. Prosecution indicted for rape. And the issue touched and concerned the age of consent. Because the judge said, because legally she can't consent to rape, he's not going to give the jury any directions on consent. And the Court of Appeal held, no, you can't do that. Even if she's under 16, you have to give a direction on consent. Another case like that was Simon Hoyt and the Queen in Jamaica. It was the same directions were given. And then in Jamaica again, there was Kevin Bryan and the Queen, in which the Court of Appeal of Jamaica held, well, it's not in every rape case, sexual intercourse a person of 16 can be left as an alternate offense. But these two Bajan cases deal with consent, and the second one, J.P. Joel Doyle, deals with the issue of consent when the person is below the age of consent. So what we say under law consent must be? It must be real, and it must be given by a person capable of consent. So already we know under law, children under 16 can't give consent. The law does not recognize that capacity. Although we know that they are having sex all about the place. But must be given by persons with mental disorders. You have to establish whether or not they can give consent, that they understand what is happening to them. Here is a surprising pronouncement. So the previous DPP, of England and Wales, Alison Saunders, she's now gone corporate, says remaining silent during a rape could be conceived as consent. I don't know where she get this from. And she was the chief prosecutor of England and Wales. So it says sometimes, and I come back again, law enforcement has not been good to victims. So what she has bought into is a sexual stereotype that the victim of a sexual assault must raise a hue and cry. She must call down the whole village and the whole town that this has happened to her. She must scream and bawl out. Although the way how things are in the society nowadays, people may think she's actually enjoying it. But she must scream and bawl out. And this is what the DPP of England and Wales has bought into. So it tells us that when we are looking for models, we don't all the time have to look abroad for it. Jamaican law is far more progressive, and the Jamaican prosecutor is far more progressive than this DPP in England and Wales. Secondly, you can't consent by an app. So there are legal apps being created in which you can apparently broadcast your consent and create what is called a legally binding agreement. Law don't recognize that. Don't recognize no consent by app. And so on. So if some of you have developed it or have been going through this, I want to think about it again. Let us come back to the Joint Select Committee report. The Joint Select Committee report has decided they are not going to give a statutory definition of consent. So they prefer the status quo to remain, where consent must be given its ordinary, natural meaning. Coming to sexual offenses. What is the age of criminal responsibility for sexual offenses? Well, the age of criminal responsibility for sexual offenses is the same as the age of criminal responsibility for any crime. It is 12 years old. Once you are 12, you can be charged with a crime in Jamaica. Section 63 of the Child Care and Protection Act. Now, some of you may remember, maybe about 2 or 3 years back, a murder case coming out of Trelawney, where an 11-year-old stabbed and killed an older boy. And many of you perhaps will recall the outrage felt by the family when the police declared, we can't charge him for murder because he's under the age of criminal responsibility. So he has to go to the family court to be dealt with as a child in need of care and protection. So as long as you're under 12, you can avoid the age of criminal responsibility. I'm going to come to a case which deals with this from Belize when I come to look at incest. Now, what the Sexual Offences Act has also done, it has also repealed the common law presumption that a boy under the age of 14 is incapable of committing any type of sexual offense. So what common law, and up to 2009 in Jamaica, you could not charge a 13-year-old for rape or any sexual offense because of the common law presumption. So section 24 has repealed that common law presumption. Now, let us look at the case of the DPP and Wayne Herrera. This was an incest case from Belize. Went to the Court of Appeal. Belize has this wonderful thing in their jurisprudence or so on, that the prosecution can actually appeal, something we have been waiting for generations in Jamaica for. So in Belize, it was an incest case. Wayne Herrera was, I think, below 14. But Belize also had a law in which it fixed the age of criminal responsibility. So when Wayne Herrera came to court, it was the clash of the common law against the statute. And so the judge actually ruled in favor of Wayne Herrera on the common law, notwithstanding the statutory provision. So the DPP appealed, and the Court of Appeal held that the court ought to have applied the statute and not the common law. Presumption. Did Wayne Herrera go back for trial? No, Wayne Herrera didn't go back for trial. So what the DPP did, they treat it kind of like a case stated. So they undertook that even if they were successful, they were not going to re-prosecute Wayne Herrera. Well, he was a child anyway, but they wanted the law settled. Let's come to the first offense. Incest. Cousin and cousin boiling good soup. So let us come back to ancient culture and mythology again. For those of you who read Greek mythology and so on, you would be aware that Zeus and Hera, king and queen of the Greek gods, were brothers and sisters. In the Bible, after the destruction of Sodom and Gomorrah, and Lot thought that God had come back for his world and judgment had been rendered, what did Lot's two daughters say? Well, the world has come to an end. We have no husbands. What are we going to do? How are we going to have children? So they made their father drunk, and they lay with him, and they conceived children. So Lot and his daughters, biblical instance of incest. There's another biblical instance. 2 Samuel 13, 1-22. The rape of Tamar by her brother Ammon is another example of incest. And for those of you who are up on your Bible, you will recall that this was a rape that led Absalom to rebel against his father. And Absalom, you know, caught in the tree by his dreadlocks and killed. So what is incest? Incest, and let me give the Jamaican definition here. Incest is committed when a male or female willingly has sexual intercourse with another who falls within the forbidden boundaries of consanguinity. Nice big word meaning you're related. And that so it defines where are the forbidden areas of consanguinity. So in Jamaica, a man cannot have sex with his mother, his sister, his grandmother, his daughter, his aunt, his niece, or his granddaughter. And in Jamaica, a woman or a female cannot have sex with her father, her son, or grandfather, her brother, or uncle, or grandson. So those are the forbidden boundaries of consanguinity. Let me move on. In Guyana, they don't call it incest. In Guyana, it is known as sexual penetration with a child family member and sexual penetration with an adult family member. Now, I want to look at how the Guyanese definition has expanded it. In Guyana, their equivalent of incest includes stepchildren, adopted children, and foster children. So, we recently prosecuted a historical sex case in Montego Bay. Get to a wild and wicked city. And when I say a historical sex case, I mean the case, the offending was over 30 odd years old. But in Jamaica, and I suspect in other Caribbean countries, there is no statute of limitations on major criminal offenses. So what happened in the preparation of this case? We had done a DNA test because up to that point the charge was incest. And this girl knows him only as, well, this big woman now, knows him only as her father and he knew her only as his daughter. Well, it turns out the DNA showed that all these 30-odd years she was a jacket. But the Crown, my colleague, did not wish to concede on the incest point. So she went to the Adoption Act and tried to get the court to find in the Adoption Act that what he did could still qualify as incest. However, the Adoption Act is silent on criminal liability in those areas. So countries like Australia, if you adopt a child and you do these things to them, you can be charged for incest. But in Jamaica, you can't. So the case kind of failed at no case submission. But that was an example, and we have since written to the Ministry of Justice, asking them to close that lacuna in the law and to expand it to include stepchildren, adopted children, and foster children. Now, in Jamaica, now let me go back to Guyana. If you look at the Guyanese definition, it is clearly gender neutral. If you look at the Guyanese definition. Come to the Jamaican definition. The offense can only be committed within a heterosexual context. The second thing about incest is that it can only be sexual intercourse. So, if a father, let me go back to the first one, go back to the heterosexual context. So if a father should bugger his son, you would have to charge buggery, but you couldn't charge incest. If a son or a brother should place his penis in his sister's mouth, you could not charge incest. You'd have to charge grievous sexual assault, because it's not sexual intercourse. So an offense committed by relatives within same-sex parameters has to be tried and punished as something else. But incest will not cover it. And the territories that have these provisions are Jamaica, Antigua, Barbados, Belize, Bermuda, Cayman, and Trinidad and Tobago. You will notice that Guyana is the outlier among these Caribbean territories. In also the Bahamas and Dominica, it can be charged if it is in the context of a sexual connection other than sexual intercourse. So it's really only 3 Caribbean territories. Guyana, and if you wonder why Guyana is so big, this PowerPoint was done by a Guyanese national, and she just thought she needed to big up Guyana on this thing. So that is why Guyana is in larger font than the others. So Bahamas, Dominica, and Guyana say that, well, you know, what the examples I described, the buggery, the fellatio, and so on, you can charge incest. But again, these territories are the minority and not the majority. So for the majority of the Caribbean, can't be same-sex, has to only be sexual intercourse. What other feature is there of incest? You cannot consent to incest. You cannot. Consent is not a defense. So if you are 30-odd years old and you decide you are going to have sex with your 50-odd-year-old father because you want it and him just look good for a man his age, you can't consent to it. You can only raise consent if you are using it as collateral to a defense of duress. In Trinidad, Antigua, Barbados, Bahamas, and Dominica, there's an express provision in their Sexual Offences Act for a defense of duress. In Jamaica and others, it is implied let me go back. Why I say it is implied. Willingly. So it is implied that you can have unwilling. So there's no express consent provision in the Jamaican statute as to it. Lastly, I come back again. 12 years is the age of criminal responsibility for incest. Common law presumption repealed. Coming back to DPP and Wayne Herrera, the Belizean case. The prosecution has to prove as a material fact the relationship of the parties. So in the pre-DNA days, the court and the prosecution have to infer that there's a familiar relationship. So you go, how you know this man? I grow with him. What you call him? I call him daddy. If his name is on the birth certificate, you tender the birth certificate and so on. In the days before DNA, so you had all this oral evidence to prove the familial relationship. And it still is allowed because, hard to believe, there are still children who are unregistered in this country. And just as a side, I once did a case. It was a, well, no, it's now Section 116. It was a carnal abuse case. We didn't have the mother because as prosecutors we prefer to call mothers as proof of age because the mothers naturally have to be present when the child is born. So they are the best persons to call for proof of age. But we have had the odd case where the mother isn't available. And we've had to call grandmother who we said, I remember when I saw her pregnant, I remember she went to hospital on a certain day, and a couple of days after that day we see her come home with a baby. The truth is you can't ask fathers these questions, many of them. Anecdotally I say this. The last case I had in which I was calling a father to prove age. We asked, so sir, you know so-and-so? Well, no, they didn't ask for no so-and-so. You know this person in the room? Pointing to the daughter. He said, yes, it's my daughter. What is her name? Boy, I know him. I don't know him, so I hear them call her Punsi. And this is the father. This is the father of the child. So we generally don't like, in practice, to call fathers to establish these things about their children. It's very rare. We get very good fathers who can come and give this kind of evidence. But the Jamaican standard is them no know. So nowadays we can prove it by DNA evidence. And the DNA Evidence Act is a wonderful piece of legislation, I must tell you. Before 2016, we actually had to ask accused persons to give their DNA. And you know what? They could refuse and we couldn't do anything about it. So you had a lot of cases in which we would like the DNA of the accused persons, murder cases, sex cases, all kinds of cases, in which DNA evidence would be relevant. And we had to go a begging, and they would refuse. Sometimes the police would trick it out of them, like one police officer who brought when the man was being taken into custody, she brought a doctor and said, well, sir, you have to be medically examined before you go into custody. No, we don't want no sick prisoner. I made the doctor scrape him cheeks. And that is how we got the DNA evidence out of the man. Unlawfully obtained evidence. The constitutional principle that you will all come to appreciate when you're on this side of the law. But nowadays, you can get the DNA evidence. And the beautiful thing about it is that you can't refuse. So there are two ways to get the DNA evidence. By a non-intimate sample, one which doesn't require a needle going into your arm to go and draw blood. And so for a non-intimate sample, so let me put it to you now, if the police in Jamaica come to you for DNA evidence, they're going to come politely. Sir, ma'am, we are asking you to give your DNA evidence. We're asking you to give a sample of your DNA, and could you sign that you consented on this form? The DNA. So if you look big and bad and say, no, I have my rights. My rights to privacy. You're not giving it. It's a wicked and evil government system. The next thing the police officer will tell you is, sir, ma'am, I am empowered by law to take it by force. And you see 4 burly policemen come into the room ready to hold you down. to come and take it. So it is best that you comply and then complain afterwards. What has the Joint Select Committee said about incest? So that Section 7 should be made gender neutral. I'm not sure the Joint Select Committee has thought this out properly, but so it should be made gender neutral. Grievous sexual assault within a family context could also be considered incest. And they have also added, and because there's now a child diversion legislation in Jamaica, where one of the perpetrators was below the age of 16, the child should not be charged, but dealt with as a matter for child diversion. And there's merit in this proposal. In 2014, I dealt with an incest matter in St. Mary. And you could see the mother was conflicted, because the boy, who was about 14, had sex with his sister, who was about 10. And on top of it, based on what happened to her, she needed surgery. She needed corrective surgery based on what happened to her. And so here is the mother coming to court. She's bringing the complainant, and she's also bringing the accused boy to court. The boy eventually pleaded guilty. But you could see the pain on the mother's face. She knows her son do wrong, but she don't want her son get a correctional order and they lock him away for years. So these are the kinds of things that happen. And perhaps if we had had child diversion, the mother would not have been so fearful. So child diversion has come, but I don't think it has been put into play, made effective as yet. So we come to the other set of offenses: buggery and bestiality. So the one on the right is actually from ancient Greece. And you know, in ancient Greece, they had, their way of mentorship was that older, mature men would take on young boys and they would groom them in this way until they reach a certain age, and then that boy would go and find his young boy to go and train and teach in the ways of the world, and so on. The other one to the left is related to a Greek myth. Any of you heard the names Castor and Pollux? This is Leda. The lady here in the painting, her name is Leda. The swan is the Greek god Zeus. So you know Zeus used to cheat on his wife. And this was the way how he cheated on his wife with Hera. But he didn't assume human form when he was cheating. He had sex with Leda in the form of a swan. Leda gave birth to twins, Castor and Pollux. And when Castor and Pollux died, they were placed among the stars as the constellation Gemini. Any Geminis in the house here? Nobody willing to own as to the origin of your astrological sign? Very well. So this area in Jamaica is not covered under the Sexual Offences Act. For this offense, you have to go to the Offences Against the Persons Act. And this is some areas, so if we've never thought about it, Roger Rabbit and his wife, you know, this is actually bestiality. It's unlawful, people. But we have our children watching these. Beauty and the Beast. Again, this is unlawful. And we tend to seem to be normalizing this kind of behavior with our children. And then there is this. And then in Germany in 2014, there was this article, granted it's in the Daily Mail, But there was this article that bestiality brothels are spreading through Germany as abusers turn to sex with animals as a lifestyle choice. Apparently in Germany you have brothels where if your tastes run to cows, goats, or chickens, you can go and pay. You can go and pay for it. So in Jamaica, Jamaica does not have an offense of bestiality. Whether you're having sex, two men having sexual connection, or you're having a sex with an animal, in Jamaica the offense is known by only one name, buggery. So there's a tendency when people say, repeal the buggery law in its totality. What you're also asking for is to repeal the law that forbids people to have sex with animals also, in Jamaica. Yes. I'm sorry, I don't think they can hear you at the back. Good day.
So I think there must have been instances where males have been raped, in the sense that, you know, another man has violated their, So in those cases, what really happens, since there is no law for that?
Buggery. Buggery. So buggery takes place when the penis goes into the anus. So if a man, as you put it, rapes a man, which by the way, in Jamaica it would not be called rape, because rape can only be sexual intercourse. So if it's in Jamaica, a male violates another male in that way, you would have to charge buggery.
And it is said that they are planning to repeal the buggery law?
There are advocates asking for it. I make no opinion on it. I leave that entirely to you as to whether or not you can. Buggery, let me tell you, so by the way, if you are into some freaky stuff, say male and female, and you desire that you want to bugger your girlfriend, you want to go into the nether ring, you can't consent to it. Consent is not a defense to buggery. Yes, can you give her the mic, please?
Yes, back to the question that she was saying. So we know that, man cannot be raped, and rape would be considered sexual intercourse. So what if a man penetrates a woman, but the woman basically forced the man to do it? It would be grievous sexual assault? It
would have to be grievous sexual assault. Because men can, under the law, only men can commit rape and only women can be victims of rape. So, it doesn't matter. It doesn't matter if you have been married and you are husband and wife and you enjoy this kind of thing. If law enforcement finds out, you can be arrested and charged. So consent is not a defense. Now, if you look at Antigua, Barbados, Bermuda, Dominica, Trinidad, and Tobago, they have separated buggery from bestiality. So bestiality is a separate offense from buggery in those countries. So in those Caribbean countries, I have maintained buggery is reserved for human beings and bestiality is for animals. In Jamaica, one term fits all. So, in 2016, the Minister of Social Transformation recommended decriminalization of buggery. If there are any Antiguans here, this law has not yet come into being. In fact, I don't even think it has passed being a thought. Because the outcry let the government decide to backpedal on this. In Trinidad and Tobago, there was a Jason Jones case. It's a case that you should read. Jason Jones from Trinidad and Tobago and Caleb Orozco from Belize. In fact, the Belizean case, you should read both the first instance judgment and you should also read the Court of Appeal judgment. For some reason, the Belizean Supreme Court website has not put up the Court of Appeal judgment, although it has been out since December of last year. I don't know why they have not put it up. But if you know anybody in Belize, ask them to email it to you. So Jason Jones challenged the constitutionality of the buggery provisions in the Trinidadian law. That is sections 13 and 16 of the Sexual Offences Act. And he managed to prevail. He prevailed at first instance, he prevailed at the Court of Appeal, and the Trinidadian government is now going to the Privy Council, which to me makes no sense, because the Privy Council is just going to uphold what the first instance court has said, and so on. The other one, as I told you, Caleb Orozco, Jason Jones. Other cases dealing with buggery, the King and Wiseman. Because in the King and Wiseman, the accused man's defense was that the person he buggered was female. And the provision of the law says mankind. The court interpreted mankind to include both genders. In the Queen and Jellyman, 173 English Report 637, a very old case. A wife who consents to buggery with her husband becomes an accomplice. So remember what I was telling you? That consent is not a defense, even if you are married. This is a doctrine that states that wives who allow their husband to do it to them, they become a secondary party. And the King and Robert Reekespeare says that buggery is committed upon penetration. Again, the slightest penetration. Again, you don't need to prove emission of seed. And then there are some others. The DPP and Judge Nevins is an Irish case as to whether buggery was a common law offense or a statutory offense. The Queen and Keith Robinson, Ainsley Rochester, and George Swire reported at 34 JLR 335 looks at the mens rea of buggery. It's a Jamaican case. The facts are a bit disturbing. So the complainant actually went to Kingston, she had missed her bus and she was going to country. It was late at night. And so she went to Kingston Central Police Station to seek shelter. These three accused persons are all police officers who took turns raping her. One of them, I don't remember it is which one. So the complainant in her evidence, because you know he turned her back ways. Complainant in her evidence said, it looked like he missed and I'm going to my bottom. So his defense was, but this shows that I didn't have mens rea for buggery. Because she said, it seemed like it's an accident. Or the Court of Appeal says, no, you can't construe it from the victim. It's not what the victim's perception is that is controlling here. It is the inference drawn from your conduct. So that defense failed. But that one deals with the whole mens rea of buggery. Then the Queen and Brown dealt with the buggery of a fowl. And the issue was, if under the legislation, fowl is an animal. So these are adventures in statutory interpretation. In the Queen and DLW, it's actually a Canadian case. It went to the Supreme Court of Canada. And it's an interesting case because the Canadian Supreme Court looks at the whole law of bestiality. And they acquitted the man because while he was doing other sexual things to this animal, he never penetrated the animal. So the principle of buggery bestiality can only be committed upon penetration is highlighted in this case, the Queen and DLW. And it's on the Canley website or the Supreme Court of Canada website. The last case, and I introduce it only for interest, is a Caribbean case. The case of Sally the cow. from the island, the nature island of Dominica. So Devril Benjamin was caught by the owner of Sally in flagrante delicto, caught in the act. And so he was arrested and charged. And it's interesting because the owner said that, you know, he had to put down the cow. And it was a cow that he loved. And the cow's name was Sally. And his children became sad. And all of these things. So actually it was a sentencing judgment on how you sentence this person. I just want to include it here as an example of a Caribbean case. You don't need to see many Caribbean cases because although we are aware of it, and anecdotal evidence, I don't know if it is true. If you are from St. Mary, please don't kill me, so me hear it. I hear this is a common occurrence in the parish of St. Mary. I do not know if this is true, but too many police officers have told me this. So, the State and Devril Benjamin is a one Caribbean case I could find. What has the Joint Select Committee said about it? The Joint Select Committee declined to make a recommendation. And so they said, this is something Parliament has to consider it on a whole. We are not going to make a recommendation that it be changed. Let us now come to sexual offences against children. What used to be called carnal abuse and still popularly referred to as carnal abuse, but now sexual intercourse with a person under the age of 16. So there have been some notable persons. You may know this person. You know, and his present legal troubles and past legal troubles. Because I don't want to compromise the present case, I will only refer to past legal troubles. So many of you are probably aware of his 2002 trial. And some of you have probably even seen the video, which I've heard is really a very bad quality. But that's what I've been told, and somebody has agreed with me. And it says something, and this is a personal bugbear of mine, it says something about how juries try these trials. Granted, there were difficulties because the girl did come and she did switch, refused to identify herself, and so on. But in there it's shown having sex with urinating on an underage girl and so on. 14 counts. And the jury found him not guilty on all 14. While I can't speak for other Caribbean territories, I can't say this happens in Barbados or so on, I can say in Jamaica, it is the hardest thing to get a conviction for any sexual offense in this country. I suspect if the statistics really were to come out and you see more acquittals than convictions. Why? Jurors say it's only a little sex. Some say the girl did too bad. Some others say, but I am the mothers of boy children. People come and tell lie on them. Others say, but this did happen to me and me turn out all right. And so, and it doesn't matter how strong the case is. So let me give an example. The case of Paul Lewis, the case of the carnal televangelist in Westmoreland, who not only did we have the testimony from the under 16 girl, but we also had his DNA which was taken from inside of her. And the good Westmoreland jury came back not guilty. In fact, members of his church used to stand out in front of the court. And when the jury and people were leaving, they would shout out, "Forgive the fallen brother! Forgive the fallen brother!" Which they did. Which they did. And again, and let me give you another example. Let me give you another example. I prosecuted a case in Westmoreland. And Westmoreland is particularly wretched in sexual cases. And I only say that as my personal opinion. It's not an indictment on the rest of the people in the parish, just the jurors. I did a case with a 9-year-old girl. Now the accused man was a good family friend. He would stay there, he would eat dinner, he was close to the family. And on Ash Wednesday, the girl was supposed to go to Savlamar for some school function. And the mother asked him, because he runs a taxi, can you take her to the function in Savlamar? But she didn't think anything of it, because I said, up to that point, nothing, he has never ever shown any of these predilections. So she entrusted the daughter with him. So she goes, he turns off into a cane piece, breaks back her seat, and proceeds to have sex with her. The police who are on patrol come across this car in the cane piece. It arouses their suspicion. Police officer gets up, goes to the car and looks and sees him having sex with the girl. Goes and pulls him off the girl. In fact, the girl even sustained an injury and had to be treated in her vagina for a wound. When that case went to the jury, 6 minutes, not guilty. 6 minutes, not guilty. Despite the fact you had the medical evidence showing the injury to her vagina, despite the fact you had the IC evidence of the police officer who pulled him off of her, not guilty. And at the time when she gave evidence, she was 11 years old and still looked like a 9-year-old. So Jamaican juries, they can be very wretched. Yes.
In that case where it said not guilty, was like by reason of what?
Pardon me?
By reason of what?
Jurors don't have to give reasons.
So, alright, so I know you said that you're the officer giving many recommendations in terms of amending certain laws and so forth. Can you like give a recommendation in terms of like taking a jury of rape cases, because since there are so many rape cases in the court system now in Jamaica, and you personally have seen the trend where there are like tangible evidence there that this person is guilty and the jury is coming back not guilty, and even they can't question what the jury says. Can't they like give a recommendation where
let me tell you,
don't use regard because of the
let me tell you, that will have to come from the people of this country. People already believe that when DPP makes recommendations, all we want to do is send people to prison. Because DPP, some people say, means direct people to prison. So it is better that the people of this country make the advocacy, raise the groundswell as to whether or not sexual offense cases ought to be tried with a jury. So that is some example of one. I'm going to come to look at sex under 16 in greater detail. The next is grooming. And grooming is a law's response to technology. It is a law's response to social media. It is a law's response to how easy it is now to contact and influence children into sexual behavior. So, Card-Cross and Jones defines grooming as where pedophiles gain the trust and confidence of children and thereby befriend them to their own purposes. So, grooming doesn't also have to be technological. It can be personal, interface. So, parliaments in Jamaica and Guyana have enacted sexual grooming provisions in their statutes. I think all the other Caribbean territories have not included grooming as an offense in their Sexual Offences Act. It's only Jamaica and Guyana. And they have followed the United Kingdom Sexual Offences Act of 2003. Now the key points and elements of the offense are: 1, only an adult can commit sexual grooming. I think the law is short-sighted here. Young people can do it too. But right now, the present state of the law, only adults can groom. There must be communication. So these are the elements: adult only, there must be communication. A meeting or any other form of communication on at least two previous occasions. And it is not necessary for the communications to be of a sexual nature. Although all the sexual grooming cases I have seen in this jurisdiction, the communication has always been of a sexual nature. The communication can take place anywhere in the world. And lastly, and this is important, the offender must either meet the child or travel to the prearranged meeting or arrange to meet the child, or the child must travel to meet the offender. So if you have 1, 2, and 3, but you don't have 4, all you basically have is an attempt. So 4 is also important. There must be some travel that takes place. So you may be familiar with a show that used to come on called To Catch a Predator. This is exactly the offense it was dealing with sexual grooming. People in chat, well, that time it was chat rooms. It wasn't WhatsApp or whatever it is nowadays. And then the persons would go to meet them. In fact, I did a ruling for a district constable who was engaging in these kind of conversations with a girl who was at Alpha. And when you read the text, boy, although he was much older than her, that girl could talk a good game. I must tell you, I was surprised. And there was evidence of the meeting. In fact, they met on a road. Well, they were supposed to meet on a road at the time. But the girl's father saw her, came up to her, ask her, what are you doing here? Come on, we'll follow you home. So the man had to do like him walk past her, like him don't know her, because the girl was in the company of her father. So those were the kind of things that happened, and that is how it came out on the evidence. Eventually it was found out because this girl was keeping a journal, and like many parents, father picked it up, began to read it, and next thing you know, he called in the police, and the district constable was arrested. In addition to the meeting, so these are the other elements. In addition to the meeting, you must have an intention to commit any kind of sexual offense. So you're not just going to meet and go eat ice cream and drink cola champagne or have KFC or so on. So there are cases that deal with it. A lot of them are English cases. I recommend these cases to read. You may not agree with me. The first 2 cases are South African cases, and they're on the SAFLI website. SPM and the state, a decision of the Supreme Court of Appeal of South Africa, I think gives a very good definition of grooming. The court gives a very good definition of grooming. The state and Ivan Muller also gives a reasonable definition of grooming. Hernando Gaviria and the Queen, 2010 EWCA CRIM 1693 on the Bailey website, gives the elements of the offense. And Mansfield and the Queen gives the reason why the law came into existence. Now the facts of Mansfield are interesting. Mansfield was about a 50-year-old man who was having problems with his wife. And when you hear the facts, you can perhaps see why he was having problems with his wife. And so he went into, at the time when this case came out, he went into a chat room where he pretended to be a 17-year-old. And he met up with this 13-year-old in the chat room. And the two of them would exchange very, very racy and very sexually charged conversations. In fact, the judge in the judgment of Mansfield makes a comment that, you know, the girl seemed to have been more mature than her 13 years of age. And so they decide to meet. And there are 2 meetings. So she pretends that she's on her way to school and she meets him somewhere and he carries her to a hotel. And things were supposed to happen. What happens? He's unable to get an erection at that point. So he decides to use his fingers, which of course, in my personal opinion, is not a very satisfactory way to culminate all of this endeavor that you have put in. But anyway, as I say now, you can see why he was having problems with his wife. Anyway, you would have thought that the girl, seeing this on the first occasion, would not meet up with him on a second occasion. But she meets up with him on a second occasion. And they go to another hotel. And he has the same problem again. And he has to finish her in the same way that he did the last time. So Mansfield and the Queen not only goes through the elements, not only gives a very clear and distinct way of how the man offended, but the judge also gives an explanation as to why this law was passed. And in his dicta, he says the law was also passed to protect young people from themselves also. The Joint Select Committee recommended the term adult be changed to person. So what the Joint Select Committee has said, in the part of the element of the offense in Jamaica, it's only adults that can commit the offense. The Joint Select Committee has said, let us change it to person. So you can actually catch persons who are not of adult years, but who are committing this offense. Now, sexual intercourse with a person under 60 is a very common offense in Jamaica and the Caribbean. In the rest of the Caribbean, the punishment varies by age. So in some Caribbean territories, you will see it is two-tiered. You know, under 12. So you have one set and greater sentencing if the child is under 12. And then you have a second tier, 12 but below 16. And the sentences tend to be lesser. But Jamaica and Guyana are unique. They don't have that two-tiered system. Once you're under 16, there's one particular sentence. So in Jamaica, sex under 16 is actually punishable by life imprisonment. And if you are a person in authority, that is, you're a teacher, you're a coach, Sunday school teacher, you're a pastor, you're a lecturer, then it's not only life imprisonment, but there's a mandatory minimum sentence of 15 years. So the lowest sentence you can get if you're a person in authority who has sex under 16 is 15 years. That's the lowest sentence you can get. And so we have had cases. So let me give an example of one in which that was the issue. Well, that was the sentence. So there was a case about a Pentecostal pastor in Jamaica who invited his victim and her younger brother up to his house. And as I say again, people tend to trust church people. So the mother didn't see anything with sending her child to pastor's house. And the man was completely wretched. I mean, when he decided what he wanted to do with the girl, he pulled her in a room and locked the door and locked the brother outside. So the brother's on the other side of the door. So the brother hears his sister struggling and so on. And I think there was an opening at the top. And he climbs up and he looks over and he sees what pastor is doing to his sister. So anyway, pastor done and fix up and carry them back to parents. So now before pastor just leave and go on, you know, have to talk to his congregants. He's talking to the mother. And the little boy keeps pulling on the mother's skirt. Mommy, 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 I have something to tell you. No, these are the actual facts of the case. Mommy, 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 I have something to tell you. And every time he does it, the pastor either interrupt him or mother say, wait man, you're the big people talking in that very adult way that Jamaicans like to dismiss children. Until finally the little boy couldn't take it no longer and him just shouts out, mommy, pastor, sex off, so and so. So that is how it came out. At trial, when the girl was testifying, I've never forgotten it, it's how my colleague reported it. At trial when the girl was testifying, she said, pastor baptized me and him sex me. And then the jury went, And no, serious. That was the juror's reaction. And that is when my colleague knew guilty is coming. So that was the actual spontaneous reaction of the jury. And he was convicted and being sentenced because he was the pastor of the girl and he was in a position of authority over her. He got a sentence over 15 years. So once you're a person of authority in Jamaica, the lowest sentence you can get is 15 years. In Jamaica, the offense is now gender neutral. The offense is now gender neutral. Before that, only males could be charged and only females could be victims. But now under sex under 16, women can be charged for having sex with boys under 16. The last 2 times we have seen these have been cases that have been brought by parents. Because the culture will not allow a boy or a male to come and make a complaint to a police officer that this old woman or this older woman had sex with me. First, the police would laugh at him. They would laugh at him as he's making his report. And I'm speaking the truth. There was a case in Clarendon. I don't remember if the boys went to Glenmuir or Clarendon College. And they decided, the 3 of them who were far more experienced, decided they were going to get their friend, whose birthday it was going to brook his ducks. And so they managed to find a prostitute on the streets of Maypen who charged only $500. And in the back seat of the car, the 2 of them went in, while his colleagues stood out on the road, standing up. Well, police on patrol, seeing a car parked, seeing 3 young males standing near a car, it aroused their suspicions. Police come out, look in the car, and see what is happening. So the woman is arrested and charged, and she's brought before the Maypen court. And it was in the age of preliminary inquiries. So the boy had to go into the witness box and give evidence. And it was really appalling the way how defense counsel treated the boy. So defense counsel, on the cross-examination, so you had a problem with what she was doing to you? You didn't enjoy it? All these kind of things. Eventually, the case was committed to the circuit and she pleaded guilty. So he was spared a second time, having to go and give evidence. So that kind of treatment of a young male, reporting that, you know, an older female has taken and abused him in that way, we have yet to see men take advantage of this provision in the law, or males take advantage of this provision in the law. And we can only conclude that the culture will not allow them to do it because they will face ridicule in the court. Proof of consent is immaterial. So sometimes when persons are arrested, they will say, once the police officers caution them, but a she give me. It don't matter. As long as she's under 16, can't consent to it. And then there's the issue of the young person's defense. So there is a defense of reasonable belief on being under the age of 23 and has never been charged for an offense. Guyana has abolished young man's defense. In fact, I don't know the rationale of young man's defense, why he must be under age 23. I can see a defense of reasonable belief that the person may have been 16, because some persons are big in body and mature looking. But if it's a person you've known for years, and many times a person they've known for years, you've seen them come to school, as far as you know they're still in school uniform, ask question. That has always been my rule of thumb. In South Africa, now, this is a case that I would recommend you read because it deals with children having sex with children, especially when they are near in age. And I would recommend you read this case, the Teddy Bear Clinic against the Minister of Justice and Constitutional Development because the South African Constitutional Court struck down those criminal provisions. They said those provisions which make it unlawful that you criminalize children when they're having sex with each other, especially when they are close in age, is unlawful, it's an invasion of their privacy, and you turn people to criminals from early. So this is what the South African court has done. And they struck it down on constitutional reasons. So it's a good case to read and see whether or not Jamaica should move in that direction. But Jamaica has passed a diversion act. While it doesn't, well, it seeks to move the matters out of the criminal court. If you look at other countries, and again I say, sometimes we tend to look outside the Caribbean as other countries being better than us. In 2018, France did not have an age of consent. A country that believes it is the acme of Western civilization. The people have invented the language of love. 2018, France did not have an age of consent. And it's only after this scandal that the French were proposing to raise it to age 15. So again, here is a case where far more progressive, give far more protections to our people than countries that we hold up as a standard and role models. So see, there are plans to set legal age of sexual consent at age 15. And there's another one. Last November, 30-year-old man was acquitted of rape after a court determined his 11-year-old victim had not been subjected to constraint, threat, violence, or surprise. So the man walked. Again from Antigua, the Attorney General, mulls raising the age of consent. And it's a discussion that we have in Jamaica all the time, where people say, we must put it up to 18, and so on. I want to tell you, I'm embracing my inner laziness. I don't want a whole bunch of cases now involving 17-year-olds and 16-year-olds crossing my desk, and I'm spending my time prosecuting these cases. As far as I'm concerned, let the age of consent stay where it is. Only because I don't want an increase in my work. And then, what do we do where people are married? Now, that religious sect in Montego Bay, you may have heard that young girls in there are getting married. You do know that the age of marriage in this country, the minimum age is 16. The minimum age of marriage in this country is 16. And if you wish to get married, underneath that, you need your parents' consent, written consent. So the question is, if I married a 15-year-old girl, albeit to their parents' written consent, and I consummate my marriage, have I committed an offense? Why have you said yes? Sorry, need a mic. Can we get the mic? She's answering my question.
Good evening. Because you said that the female that you marry is 15 years and the law only recognizes age 16 for you to give consent to be married and to have sex. And if it is that you marry the person that you don't receive even consent from the parents, then you would be charged for...
No, man, I said that I have the written consent of the parents, man.
Well, the child is not 16, she's 15, and so under law, you'll be held liable for consummating with the female.
All right. Anybody has any other opinion? Madam in the maroon and gold over there. Can you send the mic to her, please? Let me hear your view.
I think in Jamaica, it might not be rape because you have consent from the parents and from the marriage, like the marriage, but in Dominica, which is where I'm from, there is
You're from Dominica?
Yes.
Sally the cow, Dominica? Sorry, go ahead.
And there's a section in the Sexual Offences Act
Of Dominica? Yes.
That says that the person that you rape, you cannot be married to them. You can't be married if you are not married to them and if they are under a certain age. So that's my point.
Okay. The young miss in the god-awful 40s purple over there. Yes, madam, you in the front bench. Sorry, let me just declare my bias. I am a Rabalak person. That is why. Come. There should be. All right. Madam in the rainbow colors. Yes, you. No man, I can get married at 15 with my parents' written consent. Well, the interesting thing when you look at the Jamaican laws and the Jamaican statutes is that there really is no marital exception, you know. So it seems to me if I got married at 15, I'd have to wait for her 16th birthday before I could do anything with her. And a recent decision out of the Supreme Court of India has held, no matter if you're married, girl is of a certain age, it's under 18 years, and you decide to consummate in a marriage, that is rape. And I've extracted an opinion from the Indian Supreme Court, sexual intercourse with a girl below age 18 is rape. So what does the Joint Select Committee say? So the Joint Select Committee wants a close-in age exception. That is 4 years difference between the perpetrators, so they won't be put through the criminal process. Where both are under 16, they will be sent to child diversion. And the offender under age of criminal responsibility will be amended for the court, the children's court, to make the appropriate orders. But let me move on. Come to indecent assault. Now in Jamaica it's a common law offense, but the sentencing provisions are to be found at section 13 of the Sexual Offences Act. If the complainant is below 16, consent is not a defense. Repeat that again. For indecent assault, if the complainant is below 16, it is not a defense. What is the actus reus of indecent assault? 1, absence of consent by the complainant. And it must be what objective people looking on would say is indecent or sexual in nature. Now, I add that part in bold because this is to reflect 50 Shades of Grey. Where the indecent assault is of such a nature that its infliction will cause bodily harm, then you can't consent to it. There's a principle in law. You cannot consent to what will cause you harm. You cannot consent. So let us use 50 Shades of Grey for an example. So if you like to dress up in stilettos and leather and chains and whips, and you decided you're going to flog, and the person's back wail up, or blood is drawn, you can be arrested and charged. Even if not for the indecent assault, for inflicting grievous bodily harm. You can't come, the complainant can't come and say, but I consented to it. That defense is not going to fly. So you have cases like the King and Donovan, which is a sadomasochistic case, and so on. But we'll come to that soon. In Jamaica, like I said, where the victims below a certain age, no proof of consent is required. Guyana says consent must be, one, it must be express, reason of silence or lack of physical resistance on the part of the complainant, or B, by reason of sexual arousal, including orgasm and ejaculation. So, it's a question that has often been asked, especially in the context of rape cases. If a man rapes a woman and she orgasms, is it still rape? Does it vitiate the lack of consent? So what the Guyanese provision is saying, the fact that there is a physical reaction to the indecent assault, you cannot by that infer consent. So that is what the Guyanese provision is saying. So the Guyanese provision is broad. And indecent assault has this anomaly that there is no young person's defense. So these are some cases. Queen Anne Williams grabbing of a stewardess's breast while she was on a flight. Regina Goodway grabbing a traffic warden's buttocks. I guess he didn't want that traffic ticket. The Queen and Chase, the last one I'm going to look at, the Queen and Court. Now, you should all read the Queen and Court, because the Queen and Court deals with the mens rea of indecent assault. It's a case in which the House of Lords goes into the whole thing of mens rea and what is the mens rea of indecent assault. Now, the Queen and Court, the facts are that Court was a shopkeeper. He used to have a novelty store. And there was this young girl that used to come in and buy things. I think she was either about age 11 or 12. And he became enamored of this young girl. And he would start to put certain suggestions to her, such as, have you ever been spanked? Would you like to be spanked? And so on. And both times the girl said, no, she don't want to do anything like that. So the next time he came into her shop, he didn't give her any choice. He grabbed her, pulled her in the back room, pulled down her shorts, and started to spank her. And then tried to bribe her with sweets, telling her, don't tell anybody. Well, she was outraged. She went and told her mother. Police came, and again, the case is a solitary case for why you must never be sarcastic with police. Because what you say when they caution you, well and truly, will be used against you. So, the police asked him, did you do this? And his defense was I was being sarcastically saying, yes, yes, I did it. Policeman write it down. Policeman asked him, why did you do this? Man again says, why? Because I had a buttock fetish. This is what he tells the policeman. Policeman writes it down. So, no, if you read the context, you know this man was being sarcastic. But it was using evidence against him. And he was convicted. But all of that also went into the Court of Appeal, the House of Lords, looking as to whether or not, based also on his reactions there, whether or not he had the mens rea. And they concluded he did have the mens rea. Fairclough and Whip is one of these cases. These are one of these invitation type cases. So Fairclough and Whip says that an invitation to touch is not an indecent assault. And I think in Fairclough and Whip, the man exposed himself, invited the child to touch, and the child touched. And because it is a child doing the touching, the court held he could not be convicted for indecent assault. DPP and Rogers is particularly outrageous. 11-year-old daughter who masturbated her father at his request twice without force or compulsion was not an indecent assault. And Faulkner and Talbot is one of these rare cases where it is a male who was the victim and the female was the accused. So where a woman touches the penis of a boy under the age of 16 during or preliminary to sexual intercourse, which I assume means foreplay, she commits an indecent assault notwithstanding that at the time in England, women could not be charged for having sex with boys under 16. So although they couldn't convict her for the sex, you could convict her for the touching. So it's one of these cases. And the Queen and Maggie here is another case of a woman who was convicted of indecent assault on a 12-year-old and gave him a sexually transmitted infection. And all this is really saying is that whosoever, it's statutory interpretation, that whosoever includes females. Again, the Joint Select Committee declined to make any recommendations. I'm going to skip over sexual harassment because time is going. I'm going to come to sexual, or gone already, so I'm going to try to rush and finish. But I want to mention in the context of indecent assault, sexual interference and touching of a child. Now recall what I said about Fairclough and Whip and the DPP and Rogers with these invitations to touch not being covered by sexual intercourse, not being covered by indecent assault. So what has Parliament done? Parliament has created the offence of sexual touching to close that gap. So to touch directly or indirectly, or even to incite the touching. See, there's an offense for a person to invite, counsel, or incite a child to do it. So the aberrations of justice in Fairclough and Whip and DPP and Rogers have been amended in section 8. Joint Select Committee wants a provision also for indecent exposure to an adult by a child, which will cover that kind of sexual touching. We need to skip spreading disease. Let me to procuration. Let me come to prostitution. Now, when you look across the region, prostitution is not defined in any statute. So prostitution, again, falls within this context. I don't know what it is, but if I see it, I can say that it is. That's what it is. So only Antigua and Trinidad and Tobago define prostitution in their statutes. You will not find it in the Jamaica Sexual Offences Act. You will not find it in any Human Trafficking Act in Jamaica. You will not find it in any legislation dealing with sex in Jamaica. So only Antigua and Trinidad in the whole region have defined this. The offering of the body by a person of either sex for the purpose of arousing and gratifying the sexual desire of another for payment in turn. But although Jamaica has not defined it, Jamaica has prostitution-related offenses. Living on the earnings of prostitution, or in any place, whether public or privately, persistently solicits or importunes for immoral purposes. Now, in relation to 2, the issue is whether or not Jamaica has been enforcing that, because as I hear it, there's a place in St. Catherine named Back Road, where a lot of this persistent soliciting and importuning takes place. And it doesn't seem that the police are going around and driving around a Black Maria and scraping up all of these persons who are persistently soliciting and importuning. Now, in addition to the Sexual Offences Act, the Town and Communities Act covers some amount of prostitution. Person who shall loiter in any public place and solicit any person for the purpose of prostitution shall be guilty of an offense. But the offense on the Town and Communities Act is a petty sessions offense. You can only be fined $1,000. So the few times the police have enforced it under the Town and Communities Act, the women have come to court, they have paid the fine, and they've gone back, because also you don't get a criminal record if you are charged under any petty sessions offense. You don't get any criminal record. So if you curse bad word and you go to petty sessions court and they fine you $1,000, you don't get no criminal record. If you throw dirty water on your neighbor and you go there and you get convicted, you don't get a criminal record. It's just like traffic cases. You don't get criminal records for traffic cases. In the Bahamas, prostitution or the solicitation is only illegal if it occurs in public. So you can do it in private. And the Bahamas requires prostitutes to declare their AIDS status. It is strange. They have not required them to declare if they are syphilitic. They doesn't require them to declare if they have herpes. It doesn't require them to declare if you have gonorrhea, but it only requires to declare if you have AIDS. So clearly, if I am suffering from any of these other STIs, I can go about it in my merry way in Nassau or New Providence or Abaco. No, not Abaco, because the hurricane blew that down. I can do all of this without having to declare my health status. But if I have HIV, I must declare it to the authorities. I think that's a gap in the law. Especially since there are some diseases that herpes can't be cured. Herpes cannot be cured. And there are no super strains of syphilis and gonorrhea, which are difficult to treat. Parliament decided to leave this alone. No recommendation on decriminalizing prostitution. There was actually a case that went to the Court of Appeal in Jamaica and was charged under one of the tourism regulations. The prostitute was arrested and charged and brought before the Savlamar Parish Court. But she was charged under the same section that when vendors sell illegally. So she was charged under that section. And some of the magistrate convicted her under that section of the law. So it went to the Court of Appeal, and the Court of Appeal held it's the wrong section that you used. The last I want to leave with you is 10 common myths in relation to sexual offenses. And these are common things that people believe about sex cases that make them difficult to prosecute. 1, she must struggle. If she don't struggle, she wanted it. So that's one major myth that we fight against. 2, we tend to think of the rapist and the sexual offender as strangers. In the great majority of cases, they are people that we know and trust. 3, women only make these reports because they are concerned about their reputation. It's a Madonna whore complex. She must either be purer than the Virgin Mary, or she must be sluttier than the worst prostitute. General character. If you have one little blemish, you are not to be believed. Let me give an example. So I did a case involving a soldier from the JDF. A couple years ago, he was honored. He was given a badge of honor for gallantry. I just saw a case dealing with a soldier from the JDF. And he and this girl, they were into things. Both of them had their significant others. He had a fiancée and she had her boyfriends, but they would hook up. But the one thing she would never do, him could do anything to her, but she would never ever allow him to have sex with her. That was for her boyfriend only. So one day, and perhaps unwisely, she visited him up at camp. And I don't know how he was able to, but she managed to find her way at his barracks. And they started to do what she thought was the usual round of behavior. But when he began to get insistent, she said, stop. No, so that is not our thing. Well, that's not her thing, according to him, but it's a thing that he wants. Anyway, he took it by force. She went, and unusually again, she reported it immediately, because we don't find that in a lot of rape cases. People don't report these things immediately. Sometimes months pass, and it's when it is discovered that the report is made, but she reported it immediately. And she called her boyfriend and so on. So, and she told him. When she was giving evidence in court, and she was speaking about the previous occasions when he came close to Jerusalem but was not allowed to enter the city. She she had, I think, put in her statement to the police that there were 2 previous occasions, but when she gave evidence, 3 occasions. And so defense counsel using lawyer tricks, when you said, you know, 3 occasions you weren't speaking, that is not truthful. And she says, yes, it's not truthful. But I said 2 occasions, it's not truthful, it's actually 3. So I closed the prosecution's case because at the very least, there's an issue of reasonable belief that arises that she was consenting. He has raised it. The judge invites defense counsel to make a no-case submission, so I am shocked. On what basis? So when I'm asked to respond, and I respond and say, you know, my lady, it's a case of reasonable belief, it's a case that's a question of fact for the jury. What the judge said? The judge said, but this woman is a liar. He's a liar. Didn't you hear the inconsistency when she said it was 2 and it turned out to be 3 and so on? No, I am not sending it to the jury. And because I don't have a right of appeal, she directed the jury to return a verdict of not guilty. And she did so only on the basis of the character of the complainant. So it has led to real injustice, not only in society, but in court. Again, emotionality of females. Females easily get hysterical and blow things out of proportion. If they take long to report the rape, that is another issue. It means that she's not telling the truth. Number 7 is very common. The woman is fickle and full of spite. So I have one in St. Mary, and I have all the St. Mary case because I'm going to St. Mary in March, in which his defense is, I promised her a cell phone. And it's because she don't get the cell phone. I had sex with her and don't give her the cell phone. She gone to police now to report, say, I rape her. Number 8 is also not unusual. The woman under surveillance. So she figure her boyfriend may find out, so she reports rape. And there have been actually a couple cases like that I have dealt with. Well, the one that I know it is perhaps too graphic, so I won't tell the story. But that was, I can think about one. 9, disputing that sex occurred, and 10, she must suffer injury. There is a belief, especially among jurors, if there is no bruising, if there is no wounding, if there is no bleeding, that no sexual offense has taken place. And it overlaps with she must struggle and fight. They're not appreciating that fear can make you submit. I'm not appreciating that. So these are these 10 major myths. The list is not exhaustive, that I want you to reject and to educate your colleagues and compatriots on. And ladies and gentlemen, that is it. You have been very patient. Thank you very much.